McCann FitzGerald's series of summary briefings is intended specifically for in-house counsel and others whose work involves advising on or applying Irish law. Each video provides a summarised refresher on some fundamental legal rules, updates on new developments and practical guidance on the application of relevant Irish law with a focus on the issues that we see arising most frequently in day-to-day practice.
If you are a company or operating a business with a controlling interest in an EPA licensed sector, you must address the potential environmental risks and liabilities of that business to ensure compliance with environmental law. The Environmental Liability Directive underpins the statutory basis for environmental liability. It forms part of a wider framework for the regulation of environmental liability in Ireland, which is derived from the concept of polluter pays and the precautionary principle. The Environmental Liability Directive provides a framework for environmental liability in Ireland, but it cannot be considered in isolation and works in parallel with other environmental statutory and licensing regimes, including the EPA Acts and the waste management legislation. The legislation applies to all operators, and an operator is very broadly defined, with the potential to include all those who have control over a company or business, including a receiver, liquidator or lender. An operator is required to prevent or minimise environmental damage where there's an imminent threat of environmental damage. It is not a matter of waiting to see whether or not any damage will actually occur. There is a strict protection against environmental damage arising from particular heavy or licensed industries and a wider protection for the ecological environment, meaning habitats and species from all other operators. Steps can be taken in order to reduce exposure to environmental risks and liabilities. An operator is obliged to take steps to prevent and remedy an imminent threat of environmental damage. Contractual documents and standard provisions in relation to environmental damage and liability should reflect this requirement to prevent a threat of damage. Any specific financial provision that is required, for example a bond, parent company guarantee, insurance or charge, should be adequate. In order to assess the level and extent of any environmental liabilities, a business may need to carry out risk assessments, review of processes and activities, and ensure that there is effective monitoring and reporting systems in place. Also, in the context of any transaction, in particular relating to any licensed activities, appropriate due diligence should be carried out. And where environmental damage has occurred or there is contaminated land at a property, indemnities should be sought from previous owners.